Sir,
Yes,
audible, sir?
audible.
Yes. So this case, one of the case I am going to discuss, that is Prashant Chandra Rathra, suspended director of corporate Suryakant Satpathy RP. What the actually case was happened, there is number of facts, but some one what the my aim is to give some little bit idea again, not to go entire case, some little bit idea and what is the very important question of law, which is vital required for all of our every professional who are engaged in this area. So whether there is any scope for resolution professional to take any action for fraudulent transaction covered under section 43, 45, 50 and 66 IBs beyond the timeline stipulated under CRP regulation 35A. Sir, all of us are very well aware regarding these things. After appointment of IRP, COC has a expectation. My money already diverted, siphoned, or invested anywhere, so I don't know. His expectation is that the newcomer, new face will come to this assignment and he will cooperate them how the funds has been diversified or anything else. Every COC, every financial sector has a great interest in this part. What is the great interest? They expect when one IRP or RP will comes, he is well known regarding the laws and well known regarding the provisions, and he is like a safeguard, and he you can suggest to us how my funds has been diverted. So for that reason, code has given us one of the very vital area to analyze or analysis or understand or identify of many defective issues of the corporate data, because now corporate data is like a sinking. So RPI, rep are the safeguard for that company. And after getting the assignment, when you will be IRP to RP, so there is a very important work to identify the previous transactions. All of we are regarding the 43, 45, 50 and 66, which are very vital nowadays. It is known as profit transactions. So to determine a profit transaction, there is three stages. One is determination, identification, determination, as well as filing. Three steps will be there. So how all the professionals are doing in this area, I hope knows very well regarding the 35A. But here the question of law is that whether a RP can file a UPA transaction like section 43, 45 or 50 or 66 of the IBC beyond the timeline of stipulated under CIP regulation 35A. So this case, we can go through the actual judgments and everything. I'm sharing the judgment now. I hope now it is visual. So my question of law is that where the RP can file a application beyond the time period of 35A, what is mentioned in the code, this was the thing. And here the question of law has arise this, and it was started that the present appeal filed under 61 of the IBC code passed by the authority NCLT Court of Bench by order the authority on application filed by resolution professional under the section 66 of IPC directed the present applicant on respondent number 1 under the section 66 to pay the amount, corporate a certain amount of the having, which was taken the decision that this is a fraudulent under the fraudulent transactions agreed by this present applicant was. In this case, the applicant has taken one stand. The applicant was taken the stand that resolution professional under section 66 of IBC was not within the time limit prescribed under 35A. सर इसमें क्या हुआ कि रिजोल्यूशन प्रोफेशनल जो है 35A का टाइमलाइन जो रहता है, we all everybody is known that to file a forfeit transaction application, our professional friends must well aware regarding that they should go for timeline, that is one is 75 days, another one is 155 days, 115 days, another one is 135 days. So the three dates has been categorically mentioned. So in the practice career, we will find that what is for 75 days first. In the 75 days, the resolution professional is to form an opinion, and it shall make a determination before 115 days, and it shall be filed within 135 days. सर ओपिनियन कब फॉर्म करता है बिफोर 75 डेज, और ओपिनियन फॉर्म मतलब व्हाट ए आरपी डू and how he can form an opinion, that is very important here. We have to go, all of my many of the professional friends are well aware regarding this area. What is that is, sir, any of my senior, any of my friend can give this some idea that 75 days, 115 days, and 135 days. So can be interesting. The seminar can be interesting. I request to any of friend, any of participant, or any of my senior, those can give some idea regarding these things. Why that is 3 days, 3 types of days, and 3 types of cut-off date has been given. Okay, sir. So the 3 dates opinion forms means that you have to submit one opinion with the COC, sir. That is the formation of opinion date. And determination is you will determine, or you may appoint someone to determine to help in your determination, that is transaction auditor. Sir, I hope my respected number of participants must be there in a transaction auditors. Some of the transaction auditors in this here also. Sir, determination of the transactions is very important. Nowadays, no law, number of judgments. One small discussion I will say, I was appearing with a case where RP has made allegation that suspended director was sold a BMW car for the amount of 6 lakhs. That was belongs to the corporate debtor. And there is a loss of 20 lakhs. The question was, how you have determined? The court was asked, how you have determined? As per accounting standard, what is the deduction, whatever the things for depreciation? He got the conclusion that the value of car is now 26 lakhs, but it was sold for the 6 lakhs. That was sold to the suspended director's sister. So it is a fraudulent transaction. So evidence is very important, sir. So determine RP determination for valuation of a car is sufficient to identify a transaction.
Sir, the 6 lakhs you're talking about, this is the book value, sir? The asset?
Yes, sir.
Okay, okay.
My question is, sir, whether the valuation made by the RP will sustain in court of law. The book value, depreciation value, car value. So valuer will have to give a, because 66 application, which is a quasi-criminal proceeding, sir. Evidence must be there. Supporting evidence with a strong evidence. So let's come to the topic, sir. The RP has filed the 66 application on suspended directors, but beyond the 35A period, what is the mention in code 75, 115 and 135 days. Suppose, so court what has the, suppose he has filed, but in this case he has justified. In this case it was a bench, in my bench, Cuttack bench, in my Cuttack bench. I am practicing in Cuttack bench. This was in the Cuttack bench. So what happens? He has, RP has done a very good homework, and he has completely shown why there is a delay. Sir, there is, if you are any, we have on facing number, we are placing number of applications. Whatever the most of the practice people who are the IPR is in this seminar, they have the experience. They are placing number of applications for the fraudulent transaction. Number of RPs placing fraudulent transaction. Most of have the experience. So my question is that, can we file an application beyond the time limit period for the 35A, which is mentioned in the code? So that was the question with the Honorable Tribunal. So how Honorable Tribunal has concluded this one, that is very important. We have to understand. We have to understand. First, we have to go to regarding the
3 baje.
Sir, we have to go to read the reading of regulation 35A above, so that resolution professional shall make a determination. Sir, very important, sir. I request to all the people have to take very sincere. This is the shall make a determination. It is clearly mentioned, shall make a determination on whether the corporate debtor had been subject to any transaction covered under section 43, 45, 50 and 66 of IBC on and before 115 days during the shall apply to the A on and before 135. Sir, both are concluded with shall, sir. The 2 points is the very important. One is shall determine, make a determination, shall make a or apply to the authority with the application. So, sir, we all have the concept that shall is a very strict word in legal language. This phrase means bound to do. This is a mandatory. But here what happens? Honorable Tribunal, this is the tribunal held that the rules of statutory interpretation for finding out the true nature of statutory provision, whether mandatory or directory. It's very important, sir. Most of the times we people have faced before the COVID period, some judgment has came. You all have the hour regarding the 180 days is mandatory or not, 270 days is mandatory or not, 14 days application is mandatory or not. So therefore, here also 35 days is a very, in this case, in this matter actually, RP has given all the homework that he has done in the proper way, and why there is a delay he has explained. After explanation, now there is a assist test whether 35A is mandatory or directory. Sir, mandatory, directory, before that we came to know there is two words very normally used in the legal field, and most of my professionals well are in shall and may. Sir, if there is shall, then what to do? We know that mandatory. If there is a may, we are thinking it may not be mandatory. It depends upon some circumstances. So here, one case, sir, we have to go where that is Honorable Supreme Court, the state of Uttar Pradesh, and Mobadan Lal Srivastava has in AR 1957 SC 912 page number 917. Sir, it's very interesting in our career. We have to remember this thing, that is, hence the use of word shall in the statute, though generally taken in a mandatory sense, what we discuss now, does not necessarily mean that the every case it shall have that effect. That is to say that unless the words of the statute are constantly followed, the proceeding of a outcome of proceeding would be invalid. On the other hand, it is not always correct to say that word may has been used the statute in only permissive of the directory, in the sense that non-compliance with the provision will not render the proceeding invalid. So in the help of may, we cannot take an excuse for non-compliance of the provision. So the question as to whether a statute is mandatory or directory depends upon the intent of the legislature and not upon the language in which intent is clothed. So it is very interesting. Situation surrounding mandatory word and directory word used sometimes by the court of law, and some provisions, some interpretation have made. Sir, but we should have to follow both the word in strictly way, whether it is shall or it is mine. So that accordingly we have to make the practice, but there is some interpretation. Sir, sometimes some situation, according to the situation, interpretation is there. So what is the thing? Why the situation comes? One example I would say, one just for the common knowledge. So the motto of IBC is maximization of the asset, revive of the maximization of assets. How could one process administrator or one IEP or RP, how could he do? If he is finding some fraudulent transactions, that is intention with a bad intention of the governing management of the corporate debtor. So the RP discovered there is some transactions which has been underpassed or bypassed or even whatever the things. At that time, if the time period of 35A has lapsed, but at the end moment he is coming to the authority will say, no, you go away. Why should I allow? It's you should have come within the 135 days. This situation may be arise. So, sir, remember this is a peculiar situation. Sometimes it happens, but I am not saying that we will go after 300 days or after 180 days to the authority. Decide this is the fact I came with. No. We are under time bound. So the IBB has taken the professionals who has more than 10 years experience and qualified professionals will work out within a stipulated time. We are time bound. Therefore, our practice should be to follow the code as per 75, 115, and 135 days. But if there is some delay in this case, you must have to explain the reason to the authority. Authority will admit at that time surely. They will not deny. Sir, you don't come. If they are denying, that means there is the suspended directors and other management persons are getting benefit. It is the last of end of the justice for the corporate debtor whose money has been taken away or any management or dispute. Okay. So, sir, this is the very important. So, intent of the legislature and not upon the language in what intent is clothed. The conclusion will go what the conclusion has given. Therefore, drawing for the support from the judgment Honorable Supreme Court, Surendra Trading and versus Jugilal Kamalpat. That is another judgment which has mentioned in this order, Honorable NCLAT order, that no reason to interfere with the delay of condonation allowed by the authority in filing the application beyond 135 days. The resolution professional, we hold that regulation 35A is directory, and in the present case, application filed by the RP cannot be rejected only on the ground delay in filing 135 days. Sir, this is directory. Sir, please don't think that this is directly I should or I will file in my assignment after 135 days. Remember, sir, each and every day's delay reason will be counted or asked by the honorable court. So, but in our knowledge, we should have to keep within 135 days as per the code. If you do this, that will be a very, very benefit for the corporate debtor, and it will help us if there is recovery will come, that it will maximize your assets, maximize of not our assets, corporate debtor assets. Sorry. Okay. Thank you, sir. This is the question of law, and this is the finding of the court. This is the judgment which I have explained. But my request is that any learned friend or any of my respected senior professionals who are faced in 35A, they can share their experience or any questions, then we can go further judgment to what we have planned to discuss.
I filed an application
Yes, sir.
under 66 beyond
Yes,
135 days, but
yes,
probably the case might be something somehow different, because in my case, directors were not there. In fact, they are still not there, and I got an exclusion of 147 days from the CIRP period that I explained to them that because it was beyond 135 days. In fact, it was after 300 days.
yes.
But I got an exclusion of 147 days. And there was another reason that I did not get anybody to respond. I and my transaction auditor asked the questions to the CD, but the emails asking the clarification, they went unanswered.
That means you must
So
have
that was
filed
also,
an application 19 2.
yes, that
Have
was
you filed
also
19?
one of the reason for delay.
Okay. Have you filed sir 19 2 application on them?
Yes, I filed 19.2. In
They
fact,
have cooperated.
I
The
filed
judgment has.
19.2. Sir, I filed 19.2 application. Thereafter, the directors came once only. They provided some information, but they did not provide the material information and the handing over the fixed assets, inventory, and the cash in hand, which was around 5 lakh rupees.
Yes.
I followed them up so many times rigorously, but they did not turn up. Thereafter, I filed filed the contempt application, and which is pending before the adjudication.
Sir, actually, what happens in your practice career? I have seen number of 66 applications, number of 66 cases and handling. As well as as a RP, in my RP career, I have also filed three, three or four assignments. I have filed. So what the thing is going on actually? Sir, your point is correct. You have filed one 19 application. Ask the material. If material will be not there, so how could we determine, sir?
Exactly.
So
Right, sir.
that is the reason, sir. This is not a mandatory. If I have no substantial matter, this is a quasi criminal proceeding. How could I will approach to honorable court?
But sir, in that case, there is no look back period in 66, whereas it is in 43, 45, and whereas the reasons of filing the application in not in the time is similarly and equally applicable to section 43 and 45 or 50 applications.
Exactly, sir. For all the cases, sir.
All the cases, then why the look back period is not there in the six? See, there should not be look back period. There should be some reasonable grounds that
Yes.
you should file in such times, and if there are not the reasonable grounds of the sustainable nature before the court, then only it can be entertained. But I think there if there is look back period, there is no look back period in 66. There should not be in 43, 45, and 50 also. What is your opinion, sir?
Sir, 66 as the look back period. Sir, fraud definition, sir, you are well aware regarding the fraud definition.
Yes, yes, sir.
Fraud may happens from any time or any place. So there is a liberty. 66, you go through the 66 transaction, you will find that there is no look back period. Look back period you can enter into the after 2 years also. No issue. But your reason was same, sir, regarding the filing of the. But this case, sir, in the year of which year can you, sir, please, sir? What the see the actually authority was asking to comply, whether you are complied as per the 35A or not. Which year? Most probably this was in the year of 19 and 2020.
No, I filed the application in December 2022, sir. The CIRP commenced on 30th of November. I filed in 19 to 1.5 months after having no option and rigorously following them up, the corporate debtor, the employees and the directors and all and the promoters, they ran away. Then around in December last, I filed early January, I filed 19-2. Then I got the order on 17th of March 2022 that they should appear before the RP. They once appeared, thereafter they disappeared. Then I filed after 4-5 months. Again, following them up rigorously, then I filed the contempt application. Thereafter, I got the transaction audit report because the transaction auditor was also not getting the information from the corporate debtors. And
Sir, one similar
in December
similar
2020,
question.
I filed the 66 application.
Yes, sir. Sir, similar situation may comes. I am going to just explain. Sir, what we are doing in the 75 days? Forming of opinion. 75 days when you formed an opinion on which basis you have formed, the court will ask. Same situation I have asked by the court. Mr. Sahoo, what are the material with you formed the opinion? Please tell me. Honorable court asked me.
Generally, we ask that there is a transaction audit report.
What the written in the transaction audit report? Transaction auditor very clean hands, sir. You see transactions auditors reports every time. They have written this is my best of knowledge I have formed opinion. If some transaction auditor will give strict evidence, teacher and with everything, then the case can be concluded. Stand this the opinion formed of you are taking the help of the transaction auditor. Transaction auditor report is not part of a CRP process. It is some substantial part. Sir, this will help you to put on material. Determination of the transaction auditor is not stands in a 66 application. Sir, that what the evidence he has given, what the material basis evidence, you can put in the court of law. But you cannot say transaction auditor has, sir, let's say the transaction auditor has determined this is the fraud. Yes, transaction auditor is not conducting the CIP process. Transaction auditor is not responsible for determination. Transaction auditor is not responsible for the
Yes, sir. Under law, it is the responsibility of determining filing the application lies exclusively with the RP. It is the responsibility of RP only to determine the transactions. Every time we are in the court, there are other applications being heard by the honorable court. The court asks that how did you determine?
Yes, sir. That is the point. If you have no documents, sir, you have filed a 19-2 application, how you determine what the sufficient material was with you? Whenever you have no sufficient material, this is
in my case, fortunately, what happened, I got the after 6-7 months of the commencement of CIRP, I got the details of the bank, their primary and main flagship bank account.
Yes.
Then I got the statement of the last 6, 7, 8 years. So based upon that, I provided to transaction auditor, sat with the transaction auditor that these are the group companies and all, and they transferred the money and they rounded the money goal is tarah se. So that's how I did.
You have taken good effort, sir.
Yes,
very
sir.
good effort you have done, sir. As a RP, whatever the but
sir, court is silent. Court, I filed it in December 2022, and it is in the stage of just issuing the notice and for the reply of the respondents. and some of that one respondent expired and the one respondent is still not appeared. I got the non-bailable warrant issued by the court. So it is still in the stage, very early stage. How it will be determined, I don't know, sir. That's how the courts are working. Because my item does not reach. Anyway, this is apart from whatever we are discussing.
So, this is, sir,
I will
many
not go.
interesting situations happens like you also in your practice life. Sometimes we'll discuss one by one. The simple thing is that, sir, whenever my learned friends are practicing, and every time we have to file to IBBI, and in the COC decision, many times COC will sit. You see, sir, this is the funds has been diverted. This must happen. You check out this, check out this thing, sir. If you are filed a 19.2 application, you have a strong cloth. Don't worry. First point, you can understand. Second point, whatever the material with me, I am forming opinion. If material is not with me, I could not form opinion, sir. If I am also forming, I could not substantiate in the court of law. I cannot prove in the court of law. So why will worry? But sir, if you have taken an effort and find a already find from the bank statement concluded evidence, suppose transferring of the funds. One case, sir, I will say, in my career, I have taken one case.
Yes, sir.
The suspended director, what happened? The suspended director has opened another bank account in a Gramya bank, sir. RBI guideline is that
After
if
CIRP
you,
commencement.
yes,
After
after
CIRP commencement.
before CRP commencement, sir.
Before. Okay.
Before CRP commencement, when corporate debtor was NPA, suspended directors or board of directors has opened one bank account in Gramya Bank, who is not a recognized bank. Sometimes some matlab ki infrastructure is very poor, where some reports has not could not reach with the RBI or any authority. Sometimes not poor. I am not telling us poor. Infrastructure, some infrastructure poor. RBI guideline or anything was that key one, if you have opened a current account and there is a CC account or whatever the guidelines, you could not go further bank account to open a further bank. But you can open with the permission of the existing banker. But these people have not taken any permission, they opened a Grammar Bank. I was appearing for the respondent, sir. Number of transactions was happened. Number of transactions was happened because whenever if I will send the money to that bank, the banker has freezed my account, only credit, no debit. How could I pay all the things? Question was raised. Yes. You have done wrong first? Okay, no issue. Let's tell me, whatever the money has come to this bank account, why will not take this was the transaction which may comes fall under the 43 or 45, whatever the 50 or 66. So you see, in the 66, there is two subsections, 66.1 and 66.2. So that is very important issue. You should have to understand 1 and 2. In the 1, application has to file on whom, and 2, application has to file on whom. I was questioned, can you explain us? Court has asked me, can you explain us whatever the transaction has happened, why it was happened? My submission was My account has closed. Now, 200 employees are seeking for their payments. I have made payment. Accordingly, I started first transaction to end of the transaction. I showed to the court this transaction was happened due to keep the corporate data as going concern and regular business activities. But same thing was challenged in Honorable NCLAT and order some reverse has happened. So I am not going to that. Next PPT I am going to share. That is the question, sir. I want to discuss. That's very interesting also. So this is the case where whether personal guarantor is entered to include as secured creditor in the list of creditors prepared under the sections 36 of IBC, claiming right of subrogation of the under the section 140 of Contract Act. Sir, what is the thing is going in your practice career, sir? Sometimes some people has given guarantee, personal guarantee, a corporate guarantee to the corporate debtor. Sir, this is very vital. To the corporate debtor on behalf of or in favor of, not to the, in favor of the corporate debtor. And many times it is invoked by the financial institution or financial creditors. So in this fact, in this case also same happens. That is the CRP started already. The personal guarantor was given, he comes with a request to the RP that London RP, I am a secured creditor. Whether RP will treat the personal guarantor who has given guarantee in favor of the corporate debtor as secured creditor or only creditor or financial creditor. That question of law arises in this case. Sir, directly we'll go to the, that is, I'm showing another. It is not opening here. I'm opening another way. 1 minute, please. So this is the case where the appeal was under section 61 of the Insolvency and Bankruptcy Code, filed by so and so, who is a personal guarantor of the corporate debtor, agreed by the order of so and so dated passed by the Honorable NCLT Mumbai. Sorry, National Company Law Tribunal Authority. Cut. This is the Jai Prakash. Okay. Katak bench. Application shown in the TP number this, and this was a Kotak bench. This was actually transfer application. This is a Kotak bench application. So the interesting thing is that it's very simple. We all are facing such in our practice career, and we are advising some personal guarantors. Here, what happens? If you go to sir the definition of the, I'm going to, yes, this is the point. So main contents of the appellant is the where the insolvency liquidation proceeding are initiated against the corporator if the property of the personal guarantee is sold, recovery, debtor under Suspicious Acts, he is entitled to recover the amount of the corporate debtor under Section 150 of in Contract Act. Section 140 of the Indian Contract Act deals with rights of surety on payment of performance, where a guarantee debt has become due on default of principal debtor to perform a guarantee due has taken place. The surety upon payment of performance of all that he is liable for is invested with the right which the creditor had against the principal debtor. So this is the section 140. Everyone know that. But in view of the specific contention raised in the first time before this tribunal, it is to have the definition of the corporate guarantor and secured creditors. So to analyze this case as a very interesting case. This is the analysis of this case. First of all, we have to know, we all know the definitions corporate guarantee, all my learned friends know very well. And security interest, that is also means right title or interest of claim to property created in favor of or provided for a secured creditor by a transaction which secured payment or performance of obligations and mortgage charge hypothesis. Sir,
Yes, sir.
audible, sir?
Yes, sir.
Okay. Sir, both section and definition is vital here. First one is corporate guarantor, means a corporate person who is surely in contract of a guarantee or a corporate debtor. Guarantee to a corporate debtor, sir. Section 3, subsection 31, security interest means right title interest provided for a secured creditor by a transaction which is secured payment performance, whatever the things. On reading the both definitions, corporate guarantor, security interest, and secured creditor. So three definitions, whatever all my learned friends are. Just a magnetic point I am going to explain only. And a secured creditor to claim that he is a secured guarantor as defined under section 330, he must satisfy that he has got security interest as defined under 331 of the IBC. The word secured creditor also defined under 3 subsection 30 of the IBC, which means a creditor in favor of whom, sir, this is the point, and I hope all my means a creditor in favor of whom security interest is created. Sir, the definition clearly tells that a creditor in favor of whom security interest is created. Here, no security interest as defined under section 331 was created by a corporate debtor. This point is a very important point. In any of the specified modes, thereby he cannot claim to be a secured creditor to include him as secured creditor in the creditor list to pay his share amount. कोर्ट ने डायरेक्ट डिनाई कर दिया आपने सिक्योरिटी ऑन बिहाफ ऑफ और इन फेवर ऑफ यू हैव गिवन दैट मींस as per contract act security that is secured creditor and security interest whatever the definitions has been analyzed in that definition the court did not find that this has been made guarantee to the corporate debtor. A guarantee was made in favor of corporate debtor to the financial creditor. So it cannot be treated as secured creditor. Many times also in number of cases I have seen on an RP, whatever the personal guarantors and has invoked or anything, they're treating this one. This is the secured creditor, but this judgment will help them. They can go through this judgment, can clear them if they will go and read this judgment, will clear them. Sir, in this matter, what happens at the end? Petitioner applicant is entered to claim as a creditor of the corporate debtor in the view of Section 140 of Contract Act, but not as a secured creditor. ऑपरेशनल भी नहीं जाएगा, सिक्योर्ड भी नहीं जाएगा, बट फाइनेंशियल क्रेडिटर जाएगा या क्रेडिटर जाएगा. कोर्ट क्लियर लिख दे, क्लेम एज क्रेडिटर. डिफाइन नहीं किया. क्रेडिटर का डेफिनेशन है सर आपका आईबीसी में. द आरपी हैज टू चेक एंड आरपी हैज टू बी conclude that which type of creditor he will take into this section. So this is the thing, and under this preview, in this case, proceeding under IBC against the corporate debtor who is a principal borrower is going on, and at a liquidation stage, and the property of personal guarantor was sold, recovered of debt under Surface Act. The main endeavor of this applicant guarantor is that when insolvency or liquidation proceeding are initiated against the corporate debtor principal borrower, and if the property of personal guarantor is sold for recovery of the debt under the Surface Act, what I told, that is invoke of the personal guarantee, he is entitled to recover the amount from the corporate debtor under Section 140 of Indian Contract Act that we discussed. Contract, what is 140 says? 140 says that he can recover, no issue. And the liability of the surety is context with the principal debtor. Thereby, he is entitled to include a secured creditor in the list of 36 judgment NCLT, Honorable NCLAT view. What the judgment on NCLT view is told. Secured creditor, if he is claiming, he cannot claim as a secured creditor. He can, if creditor of the corporate, and in the as a creditor, he has to be included in the list of the RP claims. So next, sir, case number 3. So this is a case where COC decides to liquidate a corporate debtor, can be challenged in judicial review before the NCLT or Honorable NCLT. So all of our personal friends and professional friends very well regarding the king of, with the king in the IBC or IBC process or CRP. Learned, that is COC. So here the COC decision to liquidate the corporator can be challenged for judicial review before NCLT or NCLT. Sir, already many judgment has been, we have seen where appreciable that commercial wisdom of the COC. Using the commercial wisdom, COC can take many decisions. But Honorable NCLT had explanation under Section 33(2). So that is in the 33, there is 2 very important points. I am not going to the section, just practical approach. Sir, in a scenario, you are the IRP. One of the my cases I am telling you, sir. In a scenario, I was appointed in a case where I got IRP to RP. Normally, what happens? After appointment, IRP has to prepare a stakeholder, financial creditor or committee of creditors list and provide to the Honorable NCLAT intimation, that is 13.2. And I formed the COC. In the COC, there was 2 financial creditors. At that time, I came with 5 or 7 agenda with resolutions. Everybody knows that in the past year's meeting, what happened. So, what are the agenda and resolution? All my practicing friends and newly joined friends knows that at that time very vital is one is that first whether you will be promoted or not. So I approach COC, I want to be RP in this matter. COC agreed and told yes, you are RP. Yes, I was happy. Then I told I was made some CRP expenditure. This is the list for your approval. COC told after. Then I told them for further proceeding, I should have to appointment of value. COC told after. I told them this is the situation of the corporate debtor, and these are the need to decide RP fees after. Sir, 5 meetings, 5 number of meetings means every month, every time, lots of intimate, lots of sufficient time I called. Only one agenda first day was passed, IRP to RP. No other agenda which are vital. Whether I should publish forms, who should I will appoint valuer, who should I will make such expenditure or such appointment of foreign transaction auditors. Nothing. All are abstain. No, not no. Abstain. At the end, when CRP period is going to complete 180 days, I called COC. Abstain. So how could I do the process? Immediately I approached to the Honorable NCLT. The members given the direction to the COC. If you people are not continuing to close, then I have the power to make the liquidation. What RP has filed? Actually, I approached to Honorable NCLT with 2 conditions. If they are not cooperating in the process, there is no chance to get revival of the company, and Lordship has the ample of powers to make in 33(1) liquidate this company. But court has the liberty. Court has called, given a direction before hearing this application. You go to they give a direction to the COC, call the COC and make a resolution regarding the liquidation process of the corporate debtor. I called a COC again. I put all agenda. Normally, all my professional friends very aware regarding the liquidation process agenda, like first of the going concern concept, as well as liquidator fees concept, and as well as liquidation expenses concept, and as well as whatever the things, the 33 that is the provisions that's related. I put only one, the corporate debtor to make liquidation, liquidator fee nothing, other agenda nothing. So I put in this court, and now this case is going on. So sir, see, this is the thing is going on in the case of liquidation. So I approached in that time 33(1). Sir, what the thing is that every time when we are facing any problem, just approach to our authority, then authority will help us. So in this case, NCLAT held that 33(2) has been inserted by the act, contain the legislative declaration and intention. The COC is the legislative scheme, has empowered to take decision to liquidate the corporate debtor anytime after its constitution and before confirmation of the resolution plan. The power given to the COC to take decision under the statutory scheme, and when in the present case the decision of COC of liquidation has been approved by the authority. However, we make it clear that the decision taken by COC was in the fact of present case, and it cannot be said that whenever decision is taken for liquidation, the same is not open to judicial review by the authority and this appellate tribunal. It depends on the fact of the each case whether the decision to liquidate the corporate is in accordance with the code or not. Sir, sometimes scenario may be come, and we have seen a cases, number of cases, that is. The COC has the power. He can take the decision when the COC constituted. Why? Sir, for a process, there is two costs. One is CRP cost, liquidation cost. The financial creditor or the COC members already made some investment which has not recovered. That is bad now. Bad money. Why should they will invest more or good money in their mind? That will be in their mindset. First thing. Second thing, as a RP or IRP, when you are appointed, if you are finding that the recoverable amount or realization amount in the event of resolution or in the event of liquidation will not meet the cost of the CRP or liquidation, please put in the COC. The COC has the power to take decision. Simple. You will be also get relaxed regarding to from money compliances from the money. But you have to assume that this is the amount maybe redefine. This amount is budgeted and this amount may be realized. May realize this will not meet. Under this, COC will approve the liquidation. But if you are not finding any resolution applicant, your period has been over. So there is a chance of you can file a liquidation application. Liquidation decision is not only with the COC. You see there is an ample of power of honorable tribunal also. In many situations, like I told, whenever resolution is not available, where the expenditure could not meet, whether the time period has been lapsed, and there is no chance in circumstances to get a better bidder. So in that cases also, honorable tribunal may take the decision. So here the case is that COC decision to liquidate a corporate debtor can be challenged for judicial review before the NCLAT. So we'll see what the case actually. The appeal was filed against the order dated so and so, by which order authority has directed the liquidation of the corporate debtor and counsel for the applicant challenged the order, contested that present case where decision of COC has taken been arbitrarily taken submitted that COC never want to continue the CRP and after having in constitution after submission of the section 10 application. Sir, इसमें what happens? COC has taken the decision, but the suspended directors or whatever they are not interested, they are coming to the. That is the present case where the decision of the COC has arbitrarily taken in the submitted. COC never wanted to continue with the CRP after having been considered after admission of section 10 application. Minutes was made on so and so date, and the minutes it is reason why the company is going to be liquidated. That reason has to be prepared in the COC. Many of friends are preparing this resolution. All are aware regarding this. Reason shared by the COC for resolution. The representative of the COC conveyed to the RP that since the corporator was non-functional and completely shut since year of 2002, its machinery has almost all become scrap with some land and building, which also in a bad condition, whatever the depleted condition, or plus it has not been a going concern. It's very important. It is not a going concern since last 19 years, and there is also no possibility of its being a going concern in near future. Therefore, in such circumstances, continuation of the CRP would only involve more expenses and cost without any corresponding advantage. A very good resolution, sir. It covers every part of area. I should not spend good money on bad money. All our assets are gone scrap. It is not a going concern. If you will delay whatever the scraps also, it will going to deteriorate the value and involve in more expenses. This reason simply we all practitioners and COC suggest, and this resolution helps to him to make this is a that is the it application was approved. Sections 33 subsection 2 IB code which deals in initiation of liquidation as follows. Where resolution professional at any time during the corporate insolvency resolution process but before the confirmation of the resolution plan intimate the authority of a decision of committee of creditor approved by not less than 66% whatever the voting share to liquidate the corporate decision. The authority shall pass a liquidation order referred to subsection I and whatever the section. So here liquidation order has been passed. And now the explanation on 33.3 has inserted by Act 26 of the 2019 contain the legislature declaration and intention. The COC in the legislative scheme has been empowered to take decision to liquidate the corporate debtor. So this is a legislative scheme. Very important. The COC can take decision of the corporate debtor whether the corporate debtor has to go for the liquidation or not. That is the very important point. Sir, excuse me, sir. Sorry, sir. Okay, now it is connected now, sir. So the regions which has given the agenda item number 1, it is made clear that COC corporatory is not functioning since 19 years. Sir, I hope this is screen is shared. The screen is shared, sir.
Yes, sir. It is shared, sir.
Okay, sir. Okay, sir. Thank you, sir. So it is made clear that COC, that corporatory, is not functioning last 9 years. All the machinery has been reconstructed. Even the building is dilapidated and condition, and the CRP will be involved a huge cost. We are not convinced with the submission of the law and counsel of the appellant that COC decision is an arbitrary decision. COC is empowered to take decision under the statutory scheme, and when the present case of the decision of the COC liquidation has been approved by the authority, we see not good grounds to interfere. At the instant of the applicant, however, we make it clear that the decision taken by COC in the fact of the present case, and it cannot be said whenever decision is taken for liquidation, the same is not open to judicial review by the authority and appellate authority. Appellate tribunal, it is depends on the fact of the each case whether the decision to liquidate a corporate in accordance with IB law code is not. This is completely observation. Now we all know that, but still these cases has some challenge by the judicial review. But that judicial clearly told that it's not an preview of judicial. This is the completely decision of the COC. So next. So this is a case where authority have the inherent power to replace a liquidator in criminal prosecution is going on against a liquidator. Sir, we all IPs know before our that fit and proper person. All of these definitions, my learned friend as well as my seniors, respected seniors, everybody were regarding the fit and proper persons and the things. In this matter, what happens? Actually, very interesting. I should just explain this case. Only simple point. The in this case, actually, the conducting IP who was arrested or against whom criminal proceeding was going on. So authority was not satisfied regarding these things. Authority, due to delay in the process, authority has going to make a replacement order. The learned IP was challenged. In the order, it was mentioned that the criminal proceeding has been completed, but it is not determined whether he has done or not. He is. So the question is that the matter or the whatever allegation has not determined by the court of law. Suppose you are a IP or RP or liquidator. Due to any reason, nowadays I hope many of the department are already aware regarding the process of CRP or liquidation, and they now admitted that we are working for the interest of the public, sir. Our job also, not only we are a professional, you see, we are working for interest of the public. So we have a position in the society, sir. We're proud to say that we are also in a position in the society that we're working for the public interest. Whenever someone is working for a public interest as a court officer. Our definition is court officer. We have an authority. Someone will come or someone will make an allegation on my name or our name with a police station, affairs, CBI, whatever the authorities available. Whether they have the ample of power to arrest immediately, to disturb us. That was the reason. If they will disturb, they will threaten, they will not cooperate. So how could we work out the process? For cooling period, moratorium has imposed under section 14 for the corporate debtor. Like also, we professional has some protection is required. Suppose tomorrow, many RP or IRP friends will have regarding the behavior of the some cases. I am not saying every cases. Sometimes they are facing police affairs. My respected seniors and my friends, whether you people are finding this type of case or not, sir?
We are not finding such kind of cases. Why the FIR be registered?
Yes. I will say one case, sir. Recently, I am handling.
Okay. So FIR against you said that I have a court officer you are referring to.
Yes.
Okay.
Suppose you are appointed as a IRP or RP in the court. What happens? 19(2) application was filed.
Right.
The RP went to the registered office. One case lodged by some lady, and the concerned representative of CD was filed in the registered office. There was some lady was staying. The RP entered and misbehaved. My contention was the registered office is for to keep the records of the corporator as per definition of registered office in the compound law. That should not be kept any ready. So sometimes cases was going on. So sometimes cases harassed. What happens, sir? Another thing. RP has taken custody and control of a plant. Suppose you have taken.
May I have one query? May I have one query, if you allow me?
Yes, sir.
Suppose as an officer of the court, RP went to some place what the case you have referred to, and that case was happened. There is some lady who has filed some files kind of allegation, made some files already.
Yes.
So what is the remedy available at that point of time? You say, for example, you don't know who is leaving the office. Suppose you have you have gone to take the possession, the custody of records, etc. There are some lady, one or two lady, they have conspired together to file some case, and they have. So though you have at the strong footing, but still you have to defend yourself.
Yes, sir. My
Yes.
authority is Hon'ble NCLAT. I have to approach with my authority first. In my idea, and give the proper explanation of the police peoples. Make a party if you are making the harass by the police people, make them party also. Learned officers can be a party in this matter also. And honorable NCLT may give the proper direction after deciding these things. But sometimes what happens, if a criminal case is made allegation like a criminal activities on a RP or IRP or liquidator, at that time, whether honorable NCLT has the jurisdiction to handle this case or not, I have not gone such type of any cases. But one other experience I am telling, that is the thing is that RP has taken the custody and control, and again the CRP was set aside. RP has given back to the custody and control to the corporate debtor authorized representative. Again, authorized representative corporate debtor made one allegation with police station affair saying that Some of the material is stolen by the RP and with his team. This type of cases has happened. Sometimes what happens, liquidator is some in the corporate debtor places, liquidator has already sold in auction. Other peoples are coming and making allegation directly in the police station or anywhere. So what are the sometimes many cases have filed, and I have not seen a better result. Sir, we'll discuss in other day regarding this. So in this matter, what happens? In the case, authority has replaced new liquidator in corporate debtor in the place of appellant who was erstwhile liquidator. The adjudicating authority has noted in the order that appellant was arrested by CBI and due to which 116 days was lost due to incapability of the appellant to act as a liquidator. Loan counsel for the appellant contend that appellant was granted bail immediately. The appellant was taken the contention that I am not proved as a accused. Whatever. I am not, the criminal conspiracy or criminal proceeding has started on me, but it is not determined. Still, how I could not be act as a liquidator. Sir, my point of view, some criminal offense is on me, which is not determined. Whether for this reason, whether I should remove from the liquidator or RP office. Criminal proceeding is going on, sir. It is not proved that I am not accused of things. So this case will clear this fact, but the main thing noted that order of appellant was arrested by CBI due to which 116 days lost due to the lapse of time and due to the time bound method and time process. So this the liquidator who was arrested could not continue. So authority has appointed a new liquidator. I hope this is a very interesting case. Sir, we all are regarding the benefit of section 240A of IBC would be available to the promoters of the MSME corporate. Here, MSME corporate debtor got ample of chances and good chances to come back with a good intent to start the business. But somewhere it was tried to make manipulation, but court has given a good observation. Sir. So two things. If MSME certificate is obtained prior to the date of submission of a resolution plan, ineligibility under the section 29 of IBC would not be incurred and benefit of section 240A of IBC would be available to the promoters of MSME corporate. It is clearly told. Agar certificate, if the certificate is prior to the submission of the resolution plan, two cases will arise. Prior to the, if after CIRP, MSME certificate could apply by the RP or IRP. Possible or not, sir? Sir, my question, sir, all my senior friends, my question is that whether IRP or RP could make an application to MSME to get a certificate of corporate debtor or not. Suppose there is no certificate with corporate debtor. I am appointed as IRP or RP. I would like to make an application to MSME. Please provide me a MSME certificate. Whether MSME will reject my certificate, reject my application, or provide me certificate. or whether my IRP or RP has power, sir.
According to my understanding, if it meets the criteria, you can apply and you can get the certification if it meets the criteria of
My,
MSME.
my respected, it's very, very helpful answer, sir. Sir, it is very helpful answer because, sir, in the stage of IRP, you see, in the stage of IRP, my preliminary duty is to keep the corporate data as going concern. This is vital and vital thing. For that, anything I can do. Why not? Suppose there is a promotional activities, trade fair, or any subsidy is going on. IRP has taken, IRP can participate in that benefit, a subsidy, availing the certificate.
Right.
So now, sir, right, sir.
Thank you.
Now, sir,
Thank you.
sir, another, sir, join with me, sir. It's very interesting.
I'm here. Yeah.
Sir,
Yes.
thing is that I have right to get the certificate. Now, I have got a certificate after CIP, not prior. Prior is the clarity law, crystal law. You will get the benefit. Now, after CIP, I am the RP. I got the certificate from MSME. Corporate debt suspended director was very happy. Sir, MSME is there. I am ready to participate. In this case, sir, whether the corporate debtor can participate or not. Sorry, suspended director.
No, suspended director won't participate. Suspended director won't participate because once the company is in insolvency process, this is the duty of IRP or RP to take forward the company as a going concerns. So role of the RP as a RP becomes very vital. It's a he's a de facto chairman of the company. So he would be doing everything on behalf of the whatever for running company as a going concern. The participation of suspended director is not required.
Sometimes what happens,
It is my
sir,
understanding.
yes, sir, it's a good, sir. It is helpful for us, sir. Sir, sometimes what happens, CRP is proceeding, the suspended director got knowledge that if I am a MSME certificate, I could show in the backside, not in the knowledge of the corporate data. He applied a MSME certificate. Sir, you know, sir, sometimes we could not communicate to everybody that this company is under CRP or anything. For the taking this benefit, suspended director applied, he got a MSME certificate. Whether that certificate is valid or not, that's the question. If CRP process started, RP has the power to get a certificate that is valid. On that certificate, suspended director could not entry, backdoor entry. If that will happen, total motto of CIRP or IBC will frustrate. The motto or principle or subject of the IBC is that to revive or to rescue from the previous management to the corporate debtor. If this suspended director without knowledge of RP or IRP is going to make an application with MSME and getting a certificate and coming with that certificate saying that we have a MSME certificate, we will get the benefit under section 240A, whatever the benefits that is the like ineligibility of the 29A clauses. That is C and H, I think. Yes, C and H. So that will be not possible. Number of judgments, it is clearly mentioned. Because why? They are restricted due to safeguard of the object of IBC not to entry the suspended director or a related person or whatever things. Backdoor to the again corporate data. because the corporate debtor is now wants to free from the ex-management. Well, he has faced lots of problem with the ex-management. Additional person of corporate debtor. Okay, sir. So this was the case. The case is similar what I told you. So this is the Honorable Supreme Court holds that the objective of Section 29 IBC to cure the mischief of the person who may responsible for the financial situation of the company against trying to submit a plan and take over the company. It is initiation of the CRP proceeding, which is the relevant date, cannot be said to reflect the correct legal view, and thus we are concentrated to the observe that the law laid down in the Digambar Anand Rao in NCLAT case by the tribunal is not the correct question, whatever things. So that is the thing we got. Sir, we got the thing is that backdoor entry is not possible. If in our practice career, sometimes suspended directors or any related persons of the corporate is making approach, sir, apply MSME certificate. Yes, if required, we will sure apply. If there is any subsidy, any reason, if there is required, because it is not applied previously, if any reason, we will go for that. No issue. We cannot decline. Even COC is also in that time. If you will also discuss in COC meetings, sir, this is the reason we want to make a COC MSME certificate. This will be helpful for you also in practical life. Sir, anything, sir?
So may I ask one question? If
Sir.
now the MSME certificate can be applied to the RP can do it, but the ex-management cannot take the benefit. This is exactly the settled position of law.
Yes, sir. This is
Ex-management cannot take the management. Ex-management corporate debtor cannot take a backdoor entry on account of the RP's act. Something RP has done for the welfare of the
Yes,
actually.
sir. That is the important. Welfare. That is
This is the settled
the
position up till Supreme Court. Yes, right.
what is the thing is going on, sir? In the practical life, I am saying, sir, many RP or IRP or liquidator, whatever the position we have position, they will insist by the suspended directors or ex-management or anything to make a MSME certificate. We can give you a good plan, all the things, sir. Any act you are doing for welfare, it's welcome. Discuss in COC, make a resolution if COC is going. And remember, your application, your certification will restrict the backdoor entry of the ex-management.
Right.
That is a
Thank you.
case study.
Thank you.
Please, sir, I told, because sir, what happens in the day-to-day regular life, there is number of apps, there number of things is coming, then everybody is updated in this regard, sir. So this is another case. New Okla Industries Development Authority, Mr. Amit Agrawal, RP. The leasehold right is an intangible asset of the corporate debtor, and that the resolution professional is emphatic under Section 18F of the Code to take control and custody of asset over which corporate debtor has ownership right. सर मैं एक प्रैक्टिकल अप्रोच क्वेश्चन में प्रैक्टिकलिटी बात में बोल रहा हूं सर. वन ऑफ केस आई वाज इन्वॉल्व, वंदना एनर्जी आवर रेडियो रायपुर विंध्यावासिन दोनों वन ऑफ द केस. व्हाट हैपेंड सर, CSIDC Chhattisgarh State Industrial Development Authority has given some property to the corporate debtor. Resolve, suppose corporate debtor. Now CSIDC is stating that do one thing. You cannot insert, you cannot take my property in a liquidation state. That's the stage of liquidation. This case came to the court of law. Liquidator say that this will be the property of the corporate debtor. I could entry. Again, it is rectified or whatever. It is not part of the liquidation estate, suppose. Suppose it is not a part of liquidation estate. What is the nature of activity of CSIDC? It is a land bank. For the NOC, whatever before loan, whatever the loan, on the basis of the NOC, on the property, the financial creditor has invested crores of rupees. So liquidator approached in the different way to the CSIDC that your land bank, if someone is coming through liquidation process, if you provide them that land, again you will get royalty or anything, whatever things, you will be benefited. CSIDC is benefited. So that case was going on, and the end sometimes the decision of the CSIDC and liquidator has happened, and one mutual setting was happened, and that was closed. But here, what is the case is that leasehold right is an intangible assets of the corporator, and resolution professional is empowered under section 18F. 18F is that right of a IRP to take the custody and control. This is the right. So right. My right to take, I am a IRP or RP, my right to take the custody and control. 18F is the vital. Control custody asset over the corporate debtor. Ownership right only, not others. Honorable NCLAT held that the leasehold right is an asset under the intangible assets falling within the ambit of the section 18F IB. It is consistent to stand the respondent that the said plot is not owned by the. So directly we go to the case law. We'll see what was the accordingly we can understand. The appellant herein is sought to challenge the immunity order dated so and so passed by the London A, New Delhi Principal Bench. Authority has dismissed the application preferred by Noida for the removal of the leasehold land, the pool of the assets of corporate debtor. Observing this, the applicant is saying that I want to pull out my assets because why he wants to put, what is his stand? When it comes to the section 18F, it is only deals with the duties of intermediary. It deals with the how the insolvency professional is to perform the duties. It has not been said anywhere that IRP is confirmed with the right and he has entered to take control and custody of the assets of the corporator. It is only a section that deals with the assets could take the control of it. It is not a section creating taking away right of a somebody. Okay, no problem. वो बोल रहे ड्यूटी है, किसका राइट नहीं ले पाएगा. Okay, in this case it is a leasehold right as per section 14 the code that right cannot be disturbed during CRP period. Leasehold right property, sir. Sir, property title deed and leasehold right. Someone is enjoying a title deed, title of the property. Someone is enjoying a leasehold property. That is foreign difference is there. In this case, council appearing for the Noida appellant submitted that the corporate entity is merely a lease to the appellant, nothing more. Simple. That means no title is nothing there. Only lease is given. The case, what the interesting case. It is submitted the appellant has the first charge owner of the premises and the right to terminate the lease deed. Yes. Anytime, all of us are regarding that, like industrial property bankers, like I have given one example, that CSIDC in Orissa. That's Orissa Industrial Corporation. That is also other states are also there. Some industrial development authority is that or corporation. What are they have the land banks. It is submitted that the appellant has the first charge over the demises property. They have some term and condition that they collect some revenue in the form of, that is some development charges like rent or whatever thing. And he submitted that RP has illegally taken custody and control of premises under Section 80 of the code without taking into consideration that asset does not belong to corporator. He is completely denied. Asset does not belong to the corporate debtor. Okay. His contention is that ownership and immovable property can only be transferred by a registered conveyance deed as under Section 54 of the Transfer of Property Act. In the instant case, there is no conveyance deed executed. What I told, title deed is not executed between the parties. Therefore, no transfer of ownership under Section 54, the Transfer of Property Act. So, Transfer of Property Act clearly says that there must be a title. Here, there is no title, so property. So, RP or IRP could not take custody control of this leasehold property. It was the contention of the appellant. Then we go to the sir. It is vital. We'll see. Duties of interim resolution professional. Section 18 F. First duty. You will find in your order also. Take control and custody of assets over which the corporate debtor has ownership right as recorded in the balance sheet of the corporate debtor or with information utility, depository or anything. Assets over which corporate debtor has ownership right, which may be located in foreign country. Assets that may be not in the possession of the corporate debtor. Intangible assets, whether movable or immovable. Intangible assets, including intellectual property. Sir, intangible assets definition under income tax. It will go. Yes, sir. Sir, Section 18F again, we will clear that the code discuss both tangible and intangible assets. The IRP has to take control and custody. The term intangible asset has been not expressly defined in the court. So we rely on the explanation of the 32(1) of the Income Tax Act 1961, which defines tangible and code has not given intangible asset. So 32(1) for this purpose, subsection expression by asset and the bulk of asset means tangible being building, machinery, plant and furniture. Intangible, patent, copyright, trademarks, license, franchise, or any other business, or commercial right or similar nature, sir. Commercial right or similar nature. The reading word, any other business or commercial right or similar in clause B explanation indicate that leasehold right, which have commercial nature, would fall within this definition. Clear. So IRP could take the custody and control. So again, just some hints I am giving. 18F IRP right to take the custody and control. Custody and control of the assets. The definition of assets is clear mentioned. Tangible, intangible. So then comes to the Income Tax Act as per tangible, intangible assets. Intangible assets clearly mentioned here that intangible assets as per Income Tax Act 32 subsection 1. Yes, subsection 2 1. Sorry, subsection 1. Patent, copyright, trademarks, license, franchise, or any other business or commercial right in similar nature. Commercial right of similar nature. Sir, land nahi hoga to, if there will be no land, how the corporate will stand to start business like making a plant and machinery, office, godown, etc. So this land, this leasehold right, not land, this leasehold right is very related to business and commercial right of the in similar nature. Indicates the pure lease right which have commercial nature, we fall into definitions. So what happens in this case? We'll close. The number of judgments, number of things is there, but some magnet point I discussed. We are in the view to leasehold right of an assets under intangible assets falling within the ambit of the section 18FB. Sorry, IV. Sir, 18 section is very vital for the IRP. You just go through that and it will be clear to many things. 18F IV, it is the consistent the stand for respondent that the said plot is not owned by the corporator, but it was only leasehold right over it. We are in the consideration view that leasehold right accrue to the corporator right. Lease deed is a right vested with the corporator, is an intangible assets, and the ownership is only to extend the leasehold right based on which corporator can continue as going concern. Now what I told, without leasehold right, corporator could not go continue as going concern, and it is also significant in mention the appellant and never initiated that separate matter. He has not processed anything else. So we conclude that we found that Honorable Court found that leasehold right is right and not the plot. We also conclude the fact that substantial development and construction activity was carried on subject to plot, presumed that the corporator has considerable amount of financial resource development. The said plot, there is no denial by the appellant. Taken the stand, all the risks relevant, subject to plot transfer to. This is So in this case, the lease deed is a right vested with the corporate debtor and is an intangible assets, and the ownership is only to extend this leasehold right based on the which corporate debtor can continue as a going concern. It is also significant to mention that appellant has never initiated proceeding. So that is separate matter what happens with the appellant. He has not invoked it. But it proved that this is the leasehold right is also intangible assets. IRP has to take the custody and control on that. Sir, law is the art of science, sir. So other case studies, I think it's not permitting to help. This is a case where section 7 of application maintained in respect of component of interest became due and payable. Sorry, it was the last case I am going to discuss. So this is a case. Sometimes some scenario will come in the section 7 application, sir. One of case. There was transaction as made. Balance sheet reflects that there is a unsecured loan. All loan and friend are more strong because the number of my seniors and all the chartered accountant compensatory knows well that sometimes balance sheet contains unsecured loan or intercorporate loan, whatever, ICB. Sir, what happens? In a case, there is a loan was standing that is more than threshold limit. Every year or every month, whatever the amount, it is interest is paid. But there is no agreement when to repay. Loan is there, person is getting interest, but there is no agreement when to repay. Person can state that section 7 application filed on behalf of the corporate debtor due to non-payment of the afford loans. Yes, limitation is there, debt acknowledgement is there. Debt is there. Court asked. This is a debt is confirmed, yes, debt is there. Whether default is there? No. Because there is no agreement. So date of default is unknown. If default date is known to anyone, after default, section 7, the ingredient of the section 7 is date and default. Yes, debt is there, but there is no date of default because there is no agreement or any substantial evidence where the financial creditor has shown the company has made default. Okay, but here see, that was the example of case. So here is different. In this case, whether an applicant under section 7 of IBC can maintain in the respect of the component of interest which became payable. Sir, I will not take more time. Only single. What is the definition of debt? What is the definition of claim? What is the definition of the financial debt? Financial definition, many times it is proved that regarding time value of money. So interest is a component and full or part or any component. So question is that suppose someone given someone loan 10 crores, there is no agreement, nothing. He could not prove that there is a default, whether he can come to file a application stating that the component of interest, what I am usually getting as defaulted by someone, whether that will be treated as default or not. So in this, I am not going to the case to completely, just due to time, I am just explaining. NCLT had that after referring to various definitions, part 1, part 2 of the code, explain the scheme with the help of the decision of the case of innovative industries limited. It is a very interesting case. All of we have our, this is the, our, anything has been cleared by the Honorable Supreme Court, taking a cue from the decision of the Honorable Supreme Court in the case of others, the whatever 68 JC. We are considered opinion that, in fact, and circumstances of the present case, the application filed under section of the code could be maintained in respect of the component of interest which became due and payable without asking for the principal amount which has not been become due and payable. The question posed in the earlier part of the order duly answered. सर ये केस बेसिकली आपका डिवेंचर रिलेटेड है. डिवेंचर रिडीम नहीं हुआ है, बट सपोज समटाइम्स इंटरेस्ट कम्स, बट एज पर एग्रीमेंट इंटरेस्ट उनको नहीं मिला. थ्रेशोल्ड लिमिट इज, the interest amount is threshold, crossing the threshold limit. He came with a application section 7 that as per agreement I am not getting interest, so it is a debt. So interest is a debt also, because section 7 financial debt is completely depends on the time value of money. So this is the for today, sir. So I am going to conclude here, sir. So anything, sir, to respect all respected members and anything. So so we are going to close this session today, sir. If I will get any other opportunity, I will come with some practical exposures experience. If anything is wrong made with me or any conversation or any act from my side, I request all people have to give me excuse, sir. So we have a number of seniors and most seniors, and we are happy to see all the peoples. So thank you, everybody. I'm transferring this to Anjali. Anjali ma'am, I think they're online. We're going to close this session. Please.
Thank you so much, sir, for
Yes.
participating as a speaker in our session today. Your presentation was very informative and nice. Thank you very much, and looking forward for more sessions with you. Sir, I
Thank you.
also request you to please share the PPTs.
Sir, madam, sure, I will share it. My office will share with you. Thank you. Thank you. Can I leave, ma'am?
Yes, sir.
Yes, thank
We
you.
can conclude.